Thank you to the audience for returning to the 24th Annual George Mason Law Review Antitrust Symposium. My name is Tad Lipsky. I'm an adjunct professor at Scalia Law School. Welcome to day 2 of this year's virtual program. We saw 2 great sessions yesterday, and today we have 2 more. This is the first, Tech Platform Cases, Sound Enforcement, Politics, or Both. Our panelists are Jeff Manne, who is the founder and president of the International Center for Law and Economics, Diana Moss, who is the president of the American Antitrust Institute, Nicolas Petit, who is a professor at the European University Institute with a chair in European antitrust law, and Chris Sagers from the Cleveland Marshall School of Law at Cleveland State University. So we have a subject to deal with here that is easy to state and difficult to resolve, but sure to generate a lot of discussion. And this is the recent spate of cases and litigation brought against the larger tech platforms. The arrows seem to be coming from every direction now, and our purpose is to focus on the antitrust claims that have been filed, most notably those by the U.S. federal antitrust agencies. And I've asked Chris Sagers, who has been following a lot of these cases very closely for a long time. And I've asked him to start us off with a platform where we can all understand what are the major pieces of litigation now going on and the essentials of the claim, so we can have our discussion take off from there. So Chris, the floor is yours for a few minutes.
Thanks very much, Tad, and thanks to the Law Review for having me. It's a privilege. This is a challenge in a way. I think I'll meet it, but the challenge is trying to summarize kind of a whole lot of things happening all at once in a very short period of time in several different countries simultaneously. I think we'll meet that challenge, but only by leaving out a lot of detail. And we're not really going to be able to do justice to all these cases and their many moving pieces, obviously. But here's what we're going to do. We're going to try to say in about 10 minutes everything that's currently going on that poses antitrust risk in a significant lawsuit against a platform firm. All right. Stepping back just a little bit, I think it's interesting that all of this has happened so quickly. And I'll just say, in the United States, I feel like we've been talking about antitrust for the tech firms and talking in one way or another about the possibility that technological change and the growth of power in the tech industry is a new Gilded Age or whatever other familiar metaphor a person wants to put on it. We've been talking about that for about 20 years. As everybody knows, in the United States who follows these things, there was a very large monopolization suit in the United States against a firm that wasn't an online platform, but in a lot of ways was a predecessor to the firms facing liability right now. And that was Microsoft, which established a very large position in computer operating systems. It was sued successfully in the late 1990s in a case that terminated in 2001. All right, well, that's kind of ancient history at this point. The next major moment was about 10 years later, in 2011 to 2012. My dog feels really very strongly about antitrust and economic policy. I'm sorry. All right, so 2011, 2012, the U.S. Federal Trade Commission took an interest in one of the major firms, and that was Google. The FTC at that time believed that Google, which already by that time was very, very prominent in the space for internet search, that it might be doing things that could be anti-competitive under U.S. antitrust law. Okay, well, nothing happened. The Federal Trade Commission discontinued, closed that investigation without taking legal action. Fast forward then a few more years. Since 2012, going on about 10 years now, there has been increasingly active discussion in the United States surrounding the growth of the online firms, and certain of them in particular that have gotten very large, and calls throughout the US, popular debate in various different forms for the government to do something. In particular, in the last 4 to 5 years, that debate has grown to what I would describe as something of a hysterical pitch from various sectors. And one point that's often made is the interest in antitrust enforcement against these firms is bipartisan. It's often said that there is now consensus across the political spectrum that these firms have gotten too big and we need to revive an antitrust law that hasn't been used effectively for some time. I'm not exactly sure if the consensus is as bipartisan or consistent as people think. I think it's more complicated than that. But the point is, there's been a lot of talk, and there was a lot of talk even in the most recent political administration. And I say even because by stereotype, fairly or unfairly, it is usually thought in the United States that Republican administrations don't enforce the antitrust laws as aggressively as Democratic ones do. But the Trump administration surely talked at least a lot about bringing lawsuits in the tech sector. I believe that I should be forgiven for believing up until the end of 2020 that it was going to be all talk and nothing was ever going to happen. And indeed, nothing happened in terms of action by the US federal government until the very end of the Trump administration. The first major lawsuit by the administration against the tech platform wasn't filed until November of 2020, I believe, or very late October. Forgive me if I'm saying that wrong, but it was right before the US presidential election, and some people thought that wasn't a coincidence. Okay, well, boy, was I wrong. I thought nothing was going to happen. After that first lawsuit was filed, which was a suit by the Justice Department against Google, then a series of lawsuits was filed in rapid succession. I can't even count them all. There are now pending lawsuits against at least 3 of the 4 major platform firms in the United States, and other actions pending in other countries. And they are numerous, numerous and varied. And by the way, in all of that long digression, I'm leaving out everything that Europe has done. And Europe has done a lot. The European Commission has taken action against, in particular, Google, but other major American firms, and has been doing it for years. Some of their actions have already concluded with very significant penalties against certain firms. And so the short answer is Europe's been busy for a bit. The United States, after a lot of talk, finally took action starting in late 2020. And in the roughly 3 months since, things have hit the fan. So, okay, so that was a long wind up to put in context my brief discussion of the cases that are currently pending. So let me try to run through them. 2 qualifications. First of all, I'm probably going to leave out some cases in my list of significant cases, and other people can correct me if I'm wrong. And in particular, I'm going to do a very poor job of summarizing the European position, but fortunately we have with us a distinguished professor of European law, so he'll correct me. But here's what's going on. Oh, and by the way, it isn't just enforcement agencies and the courts. Legislatures have been involved too, and I'm going to try to squeeze that in. Here's what's going on. First big lawsuit was against Google, and that was by the US Justice Department. That was followed by one lawsuit filed by several state attorneys general, which was largely similar in its allegations, and a separate lawsuit filed by certain attorneys general led by Texas. The Texas lawsuit against Google is frequently described in the press as being a lawsuit only by Republican attorneys general, and the suggestion being that it may have political overtones. I don't know how fair that is. It is definitely a different set of claims, though. These 2 lawsuits largely accuse Google of monopolizing certain businesses in which it's prominent. And there isn't time to really do justice to the nuances between them, but I'd like to distinguish it between them just briefly. First, what I'll call the major or the primary lawsuit by the Justice Department and a large group of attorneys general accuses Google of monopolizing the business of placing ads on search results. There is a different kind of business, though, in which firms can place ads on websites, and that is on websites that don't involve any searches. Placing those ads in front of people's eyeballs is a separate business, and it depends critically on the ability of the online platform infrastructure to identify what an individual user's interests are. All right, well, Google is said to dominate the pipes, the infrastructure by which those kinds of ads are placed to, and that's what Texas challenges. Interestingly, there are now a flurry of private lawsuits against Google as well, and that isn't necessarily interesting in itself because that often happens in the United States. When the government sues somebody, several private plaintiffs will file their own suits that allege the same thing. What's interesting to me is that the follow-on suits really only follow the allegations in the Texas complaint. The private lawsuits are really fixated on that business of intermediating the placement of ads other than for search results. Okay, well, Google is also facing serious trouble in Europe. I humbly think that the most significant actions by the European Commission against a platform firm involve a couple of very big monopolization cases. What U.S. lawyers would call monopolization or unilateral cases against Google. The EC successfully showed that so far that Google monopolized both the business of search in a case that's not dissimilar to the Justice Department's current case, and in the market for distributing the operating system for Google-based cell phones, which is to say the Android operating system. So two big cases that already have concluded at the agency level and assessed very large fines. Okay, well, next is another major US platform, and that's Facebook. Facebook has been sued by the Federal Trade Commission in the United States, and in a very similar case filed by a large number of state attorneys general led by the state of New York. That's a very interesting case. I'm using up way too much of my time, but I want to say one very brief thing, which is the Facebook case, I think has the potential to be very significant in US law because it raises two theories of liability that are rarely addressed in the US, rarely exploited in the US. And those are, the case alleges what I would describe as a potential competition theory. That's a long story in itself, and I won't dwell on it. But the government challenged some acquisitions that were not what we call horizontal acquisitions. They're not acquisitions of immediate competitors. The Facebook case also made an interesting theory out of injury to consumers based on privacy. All right, it made an antitrust case based on privacy in an important way. And that's interesting too. Quality-based competition is not something we often hear about in US law anymore. Okay, well, Facebook is also facing liability in the European Commission even now. A sort of a data-related, privacy-related antitrust case is pending against Facebook there, and has a long future ahead of it, I think. Apple is another major US platform firm, much talked about, much threatened with liability. Apple so far has not been hit with the big cases. We don't see big federal cases against Apple yet, but Apple is facing what I think is a very significant private case brought against it by a maker of a popular video game. The video game is Fortnite. The maker is Epic Games. Epic is a big company, and it is shelling out big dollars for a very prominent litigation team, including a former Assistant Attorney General for Antitrust. Which doesn't mean anything in itself, except that they're serious. And I'm sure that Apple is taking the case seriously. There's another pending private case against Apple for completely different allegations that involves a reprise of a famous case against Apple from about 10 years ago involving misdeeds allegedly in the distribution of electronic books. That's a long-running thing that I happen to write a book about, available at bookstores near you. Okay, the Attorney General of Connecticut apparently is also interested in that and may file its own actions. That leaves Amazon. Amazon so far, surprisingly to me, is the company that has mostly evaded U.S. trouble. The government isn't suing Amazon in any big case yet. Okay, but I think everybody thinks that it might get sued. Probably the company that has been seen more than any other as the bad boy, the symbol of the new Gilded Age is Amazon. It's like the old Atlantic and Pacific Tea Company. It's the company that killed Main Street by getting so big. And, you know, depends on who you believe, but the press seemed to report lots of conduct that at least plausibly could be the basis of antitrust claims. So, you know, stay tuned. That may be coming. Amazon is facing pending litigation in the European Commission relating to one of the most frequently discussed theories of its abuses, and that is its use of its position as a platform to unfairly compete with third parties that sell products over its platform. And we'll see where that goes. That's potentially a big case. Okay, well, that left out all the other policymakers that have been involved in this, and they've been involved and are significant. No way I could name them all, but here are the ones that I think are most prominent and important. As everybody knows, who's been awake since about 2018, the U.S. House of Representatives conducted a long-running investigation of online tech monopoly. That resulted in a report that was a behemoth in late 2020. It was 500 pages of exceedingly detailed factual investigation of the conduct of those same four firms that I just described. The House report contains the House report, it's not like a lot of legislative work that we see in the United States, at least not like a lot of highly publicized committee hearings. That is, it wasn't the preparation for the introduction of new legislation. It read more like a complaint. It read more like the factual basis for litigation. And it lays out a long series of, you could call them allegations, factual claims that could be the basis of allegations in litigation. And indeed, quite a lot of them have in fact been alleged, oftentimes using even the same evidence that the House investigators pointed to, the same emails, the same communications or admissions that we see cited over and over again in the pending government cases. So whether it was coordinated or not, the House report seemed to go along in a very sort of parallel, interrelated fashion with the government investigations that occurred. Meanwhile, Europe is doing another big thing, totally different than the lawsuits that it's filed, the investigations it's currently got pending. Europe is going to legislate. And again, I'm going to defer to Nicolas, who will say a lot more about how this is going to work, I think. But these two bills have the potential to be big deals. So late in 2020, I believe in December of 2020, the European Commission, under an influential and well-regarded official named Margrethe Vestager, who had been the lead for EC competition policy, the EC has introduced two new bills, one called the Digital Markets Act and another one called the Digital Services Act, that essentially envision re-regulating online platforms, no longer treating them in the way that antitrust usually treats firms, which is to let them do sort of what they want, but prohibit certain kinds of conduct. Europe now proposes to treat these platforms more like what American lawyers would call common carriers. That is, we're going to impose public-facing obligations on them, directly oversee their conduct, and prohibit a series of particular kinds of actions. That is a similar position that many in the United States have been agitating for, including persons influential in the House Judiciary report. Okay, last thing I'll say is there's so much else going on that we can't squeeze it in. And I'll just mention that the national competition regulators of a number of jurisdictions have also been engaged in very prominent investigations. The most important, I think, being Australia, the United Kingdom, Germany, France, Canada has various things going on. So stuff all over the place. Just to wrap up, I thought starting 10 years ago, this was all going to be talk. It would never result in anything. It seems like it's kind of resulting in everything, and most of it has happened just in the last few months. Thanks.
Thank you very much, Chris. Obviously, a huge amount to chew on, and I think you did a great job of trying to pick the key items out of everything. I'd like to offer the other panelists a chance to, fill out or comment on what you presented. I also have a couple of specific questions that I can jump in with, but do any of my other panelists want to jump in at this stage?
I have one comment I want to make preliminarily. I think it's interesting the way you framed it, Chris, as sort of expecting that nothing would happen and then seeing this flurry of activity. And as you described, I don't know how it's fair to weigh them, but there's an enormous amount of litigation activity. There has been, as you point out, in the EU for quite a while, and quite a bit now pending in the US. And so it just made me think, I wonder the extent to which the legislative sort of responses are still sort of stuck in this mindset that nothing is going to happen under sort of existing laws, particularly, and in the US that means in court, and things move slowly in the political arena. They're just getting around to sort of addressing what they see as this lack of action, just as the action is starting to overwhelm. And I wonder, what that means for thinking about the propriety of or the need for some of these legislative type actions, several of which are very explicitly based on the assumption that the antitrust laws as currently constructed are insufficient to address this perceived problem. Like the timing was really terrible for the HJC report because this flurry of litigation activity came out, in the days following the HJC report, sort of a little bit undermining one of its sort of central premises. So there's not really a question here, but just a comment to say that that's a sort of an interesting or a potential take on the legislative activity, and I think at least it has to be the case that it's somewhat undermined by the flurry of litigation activity. That's not to say that there can't still be a basis for reform, but I think that's important.
Can I just jump in as well? And thanks, Chris, for that really good summary of what's going on. I think one takeaway from sort of the setting of the table discussion here is that antitrust has sort of come alive finally in the digital technology spaces, but as I'll talk about a little bit later, some of the really unique characteristics of the digital technology business models are such that I think these cases and the concerns about competition and consumer protection issues are going to necessarily invoke kind of a multi-pronged policy approach to the digital technology sector. There's a lot that antitrust can do, but I think when you really start digging into the scope, the breadth and the depth of the issues raised by digital technology, we are going to get more clarity about, where antitrust can really help and more aggressive enforcement is viable. Whereas when are other policy tools going to be necessary? For example, regulation of the platforms. Sort of what's going on in Europe with the DMA and other initiatives. So I think where this is going to take us ultimately is down the road of a lot of problems, but also a lot of policy tools necessary to address what is essentially a public policy problem in this sector. And I as a former federal regulator, I was an energy regulator for many years. That interface between antitrust and regulation, I think, is going to be a really interesting issue to watch, because there are points of conflict and tension. There are also points where there's compatibility between the two tools. But AAI is thinking a lot about this issue, to get ahead of the ball for when we get to that place.
Nicolas, I think I'm going to ask you to kind of take over the presentation here, and you can make whatever comment you want on what Chris has said, but I think given the way this has been set up, this would be the ideal time for you not only to react to what Chris said, but also to give your perspective on where this is going and what the EU contribution might be and what the relationship is between what the various jurisdictions are doing. So let me give you the floor for some considerable comment.
Thanks a lot, and it's great to be here. So one thing that really came to mind when Chris was talking is developments that we're currently seeing unfolding, which is that this flurry of initiatives has broken into pieces the sort of holy alliance in tech, where we're now seeing each of the large tech platforms going after the other one, trying to throw the other under the bus. And so we are seeing a sort of intense investment by each large player to disable the business model of the other, right? And the question is whether this is a good thing. And the other question is, to some extent, whether we're not seeing actually efforts from regulation actually diminishing, potentially diminishing competition by horizontal differentiation against between the various platforms. And so that's a question that I keep asking myself. In a way, what we're seeing is, when you have a dispute between Apple and Facebook and Apple and Google, you might think another time and reflect and consider that maybe these platforms were in the middle of their developmental paths towards sort of finite ecosystem with Apple for privacy, Google for free, and Facebook of the like, and maybe the antitrust intervention is breaking into this evolution in the economy, and might not be a good news if we end up with ossifying the digital economy around one business model or a subset of business models that are deemed more consumer welfare enhancing. So that's the remark that I got, and it's under our eyes. I mean, we're seeing every day and one day after the other, the large tech players complaining about what the other is doing, and that's very different from what we had in the policy convo 10 years ago. Now, the other fact that I really want to mention, and that keeps really puzzling me, is that all these cases arise against the backdrop of substantial antitrust statutory reform proposals. And so in the US, I understand there's a bill somewhere that tries to provide relaxation of existing doctrinal constraints in unilateral conduct and merger cases. And in Europe, we have this DMA, which basically invites direct regulations of large gatekeepers with really broad behavioral limitations on their freedom over contractual terms, technological design, business model and monetization strategies, and also ecosystem direction. And so it seems to me that a widespread reading in the policy conversation is that the existing cases are both instrumental and irrelevant. They're instrumental because government losses will build the evidence needed to support the view that antitrust doctrine is exceedingly conservative. And government's wins will support scaling antitrust enforcement in the marginal case by adoption of governmental regulation. But they're irrelevant because both configurations lead to the same conclusion. So the logic of lawmakers is that they need not await the courts, and they can advance at full speed with new antitrust statutes. And so, I mean, to me, the fast antitrust reform process that we are witnessing is a cause for questioning. And the issue is not law reform in itself. The issue is precipitation. I am of the view that there's a lot of learning in the cases, and that a court legislature dialogue would provide good starting points for regulation. There's lots of specification errors involved in in regulating the economy, and adjudication provides very good data points to lawmakers. I'm not saying that Guido Calabresi wrote a book about that in 1981. Also, judges are very well placed to understand the full legal topography and stress trade-offs that specialist agencies do not really contemplate or consider. So for instance, various issues in the discussion are really cross-cutting. So if you think about data portability obligation, which are in the DMA, they raise trade-offs between improved contestability for new entrants and decreased privacy for personal data users of platform services. And so I keep thinking about this in terms of, but why the rush? Why not let the courts process operates to maturity, and once we have the evidence from the cases, we can craft better legislation. So there's obviously three objections to this. The first one is we cannot wait. The courts are too slow, and the risk of irreparable harms to the economy justifies prompt action. I think that's a wrong objection. It's dead wrong. In fact, we're seeing VC funding levels that we've not seen in 10 years in the US and in Europe. And I'm not too sure that this idea that there's irreparable damage to the economy flies unless we expect higher entry levels in digital market than in any other sector of the economy, which has to be the assumption then. And no one has explained why this assumption is sound or relevant. The second objection would be well, we need to rush because the updating process through the court system creates too much uncertainty. But again, I mean, the objection can be criticized because you may really well ask which of an abrupt change in legislation after decades of legal stability is more or less uncertain, conducive than the experimental process of judicial renovation through marginal, discrete, and individualized antitrust cases. And the third objection is that we don't need more information because we have all the data. And so we understand we have enough economic knowledge that the existing antitrust laws are too permissive and that they tolerate too much anti-competitive business conduct. And I want to say here something about our existing economic knowledge. So it's very clear that in the past 50 years, the theoretical economic literature has traveled a long way. Works on network externalities, switching costs, multi-sided markets give a lot of and give a much better understanding of the reality that's out there. But very little of that work brings normative conclusions. Most of the work in these papers is essentially descriptive. It gives you a good picture of the mechanics of the economy in these sectors, but does not jump to the next stage of providing policy power through normative conclusions. In fact, the works in multi-sided markets, they actually tell you that policymaking is a very complicated exercise because it highlights that any change to the price structure creates multiple trade-offs that people tended to ignore in the past. The second thing I want to say is the economic knowledge that we have, the empirical economic knowledge this time, I don't think the empirical economic knowledge that we have of the digital economy is sufficiently complete and consistent. So most of the work that we have are essentially qualitative reports on industry structure and digital markets drafted by experts appointed by agencies. And it's a very good starting point, but I would not trust this to be an exhaustive, consistent, and complete examination of the issue under our eyes. In particular, most of these reports tend to be blind to behavioral performance factors, empirical data points that suggest that there's substantial business anxiety, technological innovation, and demand expansion investments in the digital economy. And when asked to provide an answer to these confounding facts, the reports tend to leave the issue aside, focused on structure and concentration issues. So I could say much more, but I think we don't have enough on the table to precipitate legislation at the speed at which we're doing it today. And I would certainly, end my sort of cautionary notes by saying that this matters probably more to the US than to Europe, because in Europe, regulation is today inevitable. But in the US, you have a chance to make this right by taking the time to look at the evidence in the cases and the allegations before you move to the next station in lawmaking.
Thank you, Nicolas. Again, let me offer the other panelists a chance to jump in. I have a feeling that either Chris or Diana will do so. So Chris, please take the mic for now.
Yeah, quick reaction to both Jeff and Nicolas. I took 2 points from what you said. First, we're rushing to legislate even as a bunch of litigation is just getting started. And second, it might be better to let the courts do their thing, because they have a way, courts, common, as American lawyers say, common law evolution, or evolution through adjudication. It has a way of discovering things in this, case-by-case fashion, and that might be very useful. For what it's worth, in the US, the fear that legislation is going to happen fast isn't a very serious fear. Our broken legislature is not going to regulate anything in this Congress, I would guess. And, as Nicolas mentioned, our Senate antitrust chair, Senator Klobuchar, has introduced a bill, but her bill is modest as far as I'm concerned. The House Judiciary report proposed in very abstract terms more significant ideas. At the very end of 500 pages, they spend about 20 pages talking about ideas that would be more like the European Commission's Digital Markets Act. But I'd be very surprised if anything like that is even proposed in this Congress, and it won't be enacted in the near future. So my thought is, don't worry about it. We're just getting started with a process that is unlikely to generate reform. And if it does, it won't be for a long time. Second thing is, as Jeff says, there is proof now that antitrust law in the United States works just fine because, look, we filed a bunch of lawsuits. Therefore, we don't need legislation. I mean, I'm not holding my breath that this is proof that antitrust works. I think most of these lawsuits will probably fail, and those that succeed won't succeed as some of their proponents hope. I think the odds aren't great that we're going to see a huge success in antitrust of the kind that proponents are hoping for. So I don't think that the proof is already present that we shouldn't even be thinking about legislation that wouldn't happen for 10 years, 5 to 10 years anyway.
If there's
I have comments, but I think Diana might as well. I'm happy to defer to her.
Go ahead.
Yeah, so I think one response to your point, Chris, is, of course, if the cases are likely to fail, that could just mean that they're terrible cases and they should fail. But I think it gets to a really the underlying question. In some ways, I think it's even in the title of this panel. The question whether the cases are sort of good law or politics or both. I'm not trying to suggest that somehow we should live in some nirvana world where politics doesn't enter into these things or anything like that. But I do think it's important to consider what's driving so much of all of this activity, both in the litigation and legislative contexts, and to question its value or its power as a support for the kind of reforms, again, either through legislation or litigation that are on the table. And I think it's a really weak case. And obviously I'll talk about this more when I have the floor. But I think it's just worth putting on the table now that the prospect that a lot of this is being driven by politics, that the shift that you described in your remarks, Chris, perhaps is much more of a political, for lack of a better term, shift than one driven by economics or better understanding of the markets involved or the conduct involved or anything along those lines. Now, and again, maybe that's fine. That's how our systems work. They are political systems. But as antitrust lawyers or someone concerned with the social welfare and the greater good, I think it's really problematic, because I think the basis for these things is horribly weak, for reasons I'll describe later. But you have to admit the political aspect is obviously important here, and it's very hard to tell what's driving it and what's really supporting what's going on.
Let me ask this, Jeff. I that's all fine. Let me ask, why shouldn't it be political? Or asking the same question a different way, why hasn't it always been political from both sides in the following sense? That is, both conservative and liberal positions on antitrust are always inherently political, because they imply empirical questions that you could ask scientifically in principle, but nobody really has answers to. So we have to make judgments based on how we feel about them, which is essentially ideological. Like, why shouldn't it be that way?
Sure.
And if there's an ideological shift in American opinion, why isn't that relevant and appropriate?
I knew who I was talking to when I said this. I tried to suggest that I get that I mean, that is the system we have, and I'm not saying that it's inappropriate. I am saying that it may end up being a quite costly mistake. But I'm not. But of course, politics drives a lot of this, and you make a great point, and one that I think is really important to also get out on the table. It relates to what Nicolas was saying, which is that there's massive amounts that we don't know, and in any process in which you have to undertake decisions under uncertainty, you're going to be taking decisions under uncertainty. The question is, of course, the error cost question. How much information at what cost do you want to collect before you make decisions? I take that to be essentially the point that Nicolas was making, and I think it's I would say, you'll say it's just ideological. I would say, well, error costs suggest that a proper error cost assessment suggests we should refrain from refraining from regulating is different than regulating. And obviously we'll have disputes about that. But to the extent that it's politics on both sides, I think I could make a defensible case that even if it's politics pushing against moving forward with regulatory interventions here, that in a world of uncertainty, on balance, that's preferable.
I have a follow-up question for Nicolas. Nicolas, you made the comment in your remarks that most of the empirical analysis done on the digital ecosystems has been by former agency-appointed experts. And I think what you said was most of that has focused on sort of the structure and the structural issues in those markets, market concentration and shares and market dominance. But what has been overlooked, if that's an accurate description, is how the ecosystems have performed. I think you used the term behavioral performance. As an economist, I'm interested in what more specifically what you meant by that, because it feeds into what I'm going to be saying.
That's a great question. I'm very grateful for that, and I've been really struck by the fact that most of the report that we read regurgitates a modern version of the SCP paradigm by telling you in digital it's just the same story with qualitatively higher levels of entrenchment, monopoly durability, and economies of scale. But the question has not been put whether the efficiency benefits associated with these structural dynamics deliver qualitatively higher levels of consumer surplus. And this is probably something that it will take 10 to 20 years to completely unpack. But the emerging evidence that we get from empirical studies by Eric Brejnolfsson and others tend to suggest that we should not be oblivious to the consumer surplus that these technologies deliver, correcting for privacy harms and targeting and other related issues. So that's one. The other type of performance indicators that we are notoriously very weak at understanding in the antitrust community are related to firm level behavioral activity, anxiety, and how would I say? Sometimes I talk about patient capital. So you can go to a lot of data points that are within the firm, things like whether the firm returns earnings or whether the firm retains earnings, the R&D at a quite disaggregated level, the R&D allocation choices, the question whether there is internal competition to the company. So, you can think about Facebook Messenger and WhatsApp, or you can think about Google Maps and Waze. And this firm level evidence is something, the way the firm is organized, the way the firm decides on capital allocation choices, the way the firm decides on expenditure, the way how much the firm hires, for what lines of business and divisions. These are things which are completely out of the picture, but they would give you a good sense as to whether the firm is a lazy monopolist, in the words of John Hicks, or a firm with inertial behavior, in the words of Liebenstein, or whether it's more of the traditional railroads type monopolist who just sits back and enjoys the quiet life.
I'll suggest one other amendment to that that I think Nicolas will consider friendly is, of course, that lack of consideration of those things presents a potentially stilted picture. But also, I think there's a lack of appreciation for the consequences of disrupting the organizational choices, the allocations of decision rights and various assets and resources within a company. And again, I mean, I'm not saying this is, I can see Chris shaking his head already. I'm not saying this is dispositive, but I do think it's important that most of our antitrust, it takes a kind of black box picture of the firm in a way that plenty of economics abandoned, many years ago. And we say that we're right there at the forefront of economics, and yet there are whole fields of economics and management studies and the like that are maybe very difficult to incorporate, but we should at least try.
I have to say amen to that, Jeff. Right now, AAI is doing some really greenfield research on why we need a multidisciplinary approach to evaluate the digital ecosystems. That means more than just law and economics. It means bringing in the business school perspectives, marketing, strategic management. I mean, these are really unique animals. And, we have a long history of taking a multidisciplinary approach to understanding competition problems. So, stay tuned for our research, which will be coming out on that.
Great, I look forward to it.
I'll just say one last thing. Jeff and I have said this to each other so many times in public that it's, I don't know. I still think it's useful.
I think we should just play the recording. We should just record it.
We should go on the road, man. It'd be awesome. But no, I mean, this is a very familiar, and I am finding myself kind of the lone voice for this vision, but I'm used to that. There's a very familiar tension in antitrust, but in other kinds of economic regulation too. And that is, Jeff talks about uncertainty, and he mentioned error costs, and that's a very familiar argument. I agree, and I think he and I agree to a large extent that is kind of the most important idea, at least in antitrust enforcement. I mean, the fundamental question is this problem of what kind of mistakes are more important? Is it more costly to society to let the government stick its big nose into markets without knowing for sure what it's doing? Or is it more costly to society to say the government better stay out because corporations are adequately constrained by markets and what's good for General Motors is good for America. I tend to think that what's good for General Motors isn't necessarily good for America. I think that uncertainty poses a challenge not only for government interference, but also for government choices not to interfere. Jeff said that, choosing to refrain from regulation is not the same thing as regulation. It is safe. It's the safe thing to do instead of the rash thing to do, which is regulate. He knows perfectly well I'm not saying anything to him that he and other conservatives haven't heard. There is a view that, in fact, the two things are actually quite similar, and the problem of failing to interfere also poses risks, the size and danger of which are uncertain. So, I mean, when a person like me, say, comes on a panel and says, I don't care that I don't know for sure what the costs are going to be. I also don't care that my position doesn't incorporate the best or the latest economics, because after all, economists have said so many things that conflicted with one another so radically and so often were proven wrong over the last 200 years of reasoning that I'm not sure we have to incorporate everything an economist ever thought. But the problem is, when I come onto a panel and say, let's sue some people, let's actually enforce these laws and see if society doesn't actually do a little better when we act that way than it has over the last few decades, because it seems to me like it hasn't done all that well. When I talk like that, people like Jeff say, well, you're just kind of jerking your knee. Everything you say just sounds like you don't like corporations and you don't like rich people and you don't have much of a theoretical perspective. But when I hear that, to me, it sounds like, well, you don't really have much of a theoretical perspective either. You just don't like the government. So we've chosen our own ideological bad guys and follow them somewhat impressionistically. And I got to tell you, I'm just not that convinced that we make this policy better by waiting and letting every economist say whatever they want to say.
Let me move things along by, I want to make just a brief response to Chris. And
Sure.
Chris, I promise you, Jeff and I aren't ganging up on you, don't worry.
Oh, you can, bring it.
I wanted to allude to two basic historical features of the American legal landscape that tend to support the don't mess around approach, whether it's regulation or antitrust. And that is, particularly in this field of monopolization, abusive dominance, unilateral conduct, and especially where advanced technology intensive firms are concerned. It seems to me you can look at the regulated tradition in the real Gilded Age, when we were talking about oil and railroads, and where we decided to create an interstate commerce commission to mandate outcomes that we thought originally were going to be more competitive, but which I think, ultimately the relatively quick and structural antitrust remedy was effective with regard to Standard Oil, but the regulation tradition, which started with the railroads and the Interstate Commerce Commission, was ultimately discarded and really regarded as a historic mistake. And the second thing is that there's a kind of an analog to the ICC mistake in antitrust law, which is from time to time over the course of antitrust history, we have the legal system, the antitrust enforcement system has kind of blundered into a judicial / agency regulation of a significant industry, whether it was the meat packers decree or the Paramount decree or the original final judgment in the 1950s AT&T case or the IBM case brought about the same time, or United Shoe Machinery, which seemed to have kind of the same lesson, which is it probably was a mistake to intervene if the vision you had was that there was going to be kind of long-term regulatory, and whether it's under a regulatory agency or an antitrust agency enforcing a consent decree, if it was going to require a lot of long-term monitoring, twiddling, setting terms of access, and so on and so forth. So I thought that would be a good comment to make, even though you don't get to respond to it right now, Chris, as a transition to Diana, who I believe is going to make a presentation that can help us look in a 20,000-foot comprehensive way at all these different devices that society can use to improve the public interest in the way that the digital economy is performing. So Diana, let me turn the floor over to you with that.
Thanks, Ted, and of course, thank you to the law school for inviting me onto this panel with my colleagues. Always a good discussion. So yes, I've been tasked with the question of whether antitrust is really up to the job for dealing with some of the competitive problems raised by the big techs. And so I think the answer to that is yes and no, which we'll get into. And I'll do that sort of in three parts in the time that I have available. First, I think to get into it, we have to sort of set the stage a bit. And without getting into too much detail, since we've already talked about error cost analysis, I will say that I think error cost analysis has hit the digital tech sector pretty hard. It's hit the economy, the US economy pretty hard over the last 40 some odd decades. We're now seeing all the economic evidence of the fallout from permissive merger policy, really a lack of any monopolization enforcement, and sort of ups and downs on the Section 1 front in terms of cartel busting and that sort of thing. And just to be clear, error cost analysis at its core compares the costs of mistakenly challenging benign or pro-competitive deals to the costs of mistakenly not challenging anti-competitive deals. And a lot of weight has been given to the risks of mistakenly challenging benign or pro-competitive deals. That's kind of how we got into the box we're in now. So as applied to digital tech, we see evidence of this everywhere. A year and a half ago, I did a paper on the record of weak enforcement, merger enforcement in big tech. Sure enough, out of the hundreds of reportable transactions, only one was challenged by DOJ, Google ITA in 2009. We've now updated that data and we'll be coming out with a report shortly on that. But the general concern has been sort of a hands-off the digital tech sector, driven by concerns over disrupting dynamism, and frankly, this red herring concern about, killing the goose that laid the golden egg, which is the VC venture capital funded model that says, oh, look, this is what nurtures big tech. We can't possibly do anything that strikes at the heart of that model. That's a red herring. Antitrust has never given deference to models of innovation in any particular sector. It's a generalist tool of law enforcement. So I think to sum up, the policy of forbearance in big tech has been proven wrong. We have cases now to prove it. Yes, as Chris mentioned earlier, they've come late, but and we don't know what the outcomes will be, but what we do know is enforcers finally got it together and filed some cases. Okay, so moving on to talk about, is antitrust up to the task? Considerations we might want to think about that support a finding of yes should be really prefaced by saying antitrust can't reach to all problems that are raised by digital tech. I alluded to this earlier. We've got economic problems raised by the largest of the digital technology platforms, and by the way, also the up and comers. We should be keeping our eyes on companies like Zillow, which is now taking over online real estate, and the agricultural biotechs who are now into digital farming and who have these completely enclosed, insulated systems of traits, seeds, chemicals, and farmer data. Okay, so economic issues, social issues, political issues, all raised by big tech. antitrust can reach to some of those problems, but not to all. And we need a really good methodology for sort of unpacking what antitrust can reach to. Yes, the consumer welfare standard can reach to the problems raised by big tech. I have always said that. I think we've got the cases to prove it now. The biggest development, obviously, is that the cases against Facebook focus on non-price dimensions of competition in personal social networking services, where harmful practices have degraded the quality of the user experience, particularly as it is patterned out in privacy violations. So yeah, the standard is capable. The question is, how widely will the standard be applied to the full reaches of its capability? And I think if you look at Mike Lee's recent statement and Senator Klobuchar's bill to strengthen merger enforcement and monopolization enforcement, I think what we're looking at is not a rebuild on the engine, but more a 100,000-mile maintenance approach, right? We're not looking at a complete overhaul of the laws. So that's what supports the adequacy of the antitrust laws. What we need to think about when we are skeptical that the laws are up to the task is that digital tech presents some really unique characteristics that raise issues for antitrust analytics and may require a different way of thinking. So we all know that the digital ecosystems, which are often supported at the center or the hub by a platform, and actually, which is an engineering concept, by the way, it's an economic engineering concept. We see network effects on the demand side. We see scale and scope economies and data on the supply side. We see multi-sided markets, winner-take-all markets. I think most importantly, the centrality of data collection and data processing and enhancement in the digital ecosystems is the value proposition. That is the value proposition. It is the central core of data and in data enrichment that allows the ecosystems to navigate users throughout the ecosystem through a series of interconnected markets. Without the data and the data enhancement, the value proposition falls apart. And so the digital ecosystems have every incentive to violate user privacy to fulfill the value proposition that they are dealing with. We also see really a lot of market failures in the digital ecosystems. We see information asymmetries and privacy. Consumers say they value their privacy, but then what they do in the ecosystems completely turns that on its head. We see data externalities. So all of this stuff kind of strikes at the heart of the assumptions that we use in antitrust analytics and market analysis. Consumers are not really behaving rationally. The digital ecosystems are not really accommodating preferences. They are shaping preferences. All of this will affect market definition, competitive effects analysis, efficiencies analysis, and remedies. And the bottom line, I think, is that antitrust remedies may not be able to address all of these problems. So, for example, breakups, will create smaller ecosystems with a platform at its core. So that will create sort of little seeds that could easily grow into new monopolies because of all of these inherent unique economic characteristics, like winner-take-all markets, right? So the gamble there with breakups is, can we create these little seeds of digital ecosystems, and will we provide enough time and hold back the growth of dominance to facilitate inter-system competition, inter-platform competition? And so that's a big if. That's a big if. We may need in parallel, for example, regulatory regimes to deal with what I call intra-system competition, promoting competition on platforms through access and non-discrimination types of regulation. But that's not really for the courts. That's for regulatory agencies to engage in that type of access, non-discrimination, interoperability regulation. I'm a former federal regulator, and that's what I did for years, was look at those types of things. So finally, what is needed? What do we need to do? We've got some, antitrust laws can handle this. We've got some, maybe not so fast. So I think we need to look forward and look at the digital ecosystem business model, which is growth by acquisition. So we see in the digital ecosystems acquisitions of very small rivals, which build out the ecosystem, but also reinforce the core platform, and have built out over the last few years, the central data collection and data processing capabilities. We are now passing into an era where the digital ecosystems, the big five, have solidified their positions in data analytics. That's the engine. That's the engine that drives the ecosystems. We're now seeing them go into other areas to build out their ecosystems. For example, provision of energy services, healthcare, education, delivery services. They have built their platforms. They have built their data analytics. They are fully mature or fully maturing in that area. Now they're going into another round of expansion. So the very nature of these acquisitions is that they are sometimes very small. They are sometimes all about the acquisitions of small potential nascent rivals. And all of that flies under the HSR reporting thresholds. And so that will be a question that absolutely must be addressed. In parallel, having just updated our data on merger enforcement, we're still at a dismal, 2.5% challenge rate for acquisitions in the digital tech space. This compares to a 15% challenge rate across all sectors. And this is based on DOJ and FTC data. We also know that the potential competition doctrine doesn't work very well in the digital ecosystem spaces. Proof of entry, that the potential entrant would have entered but for the acquisition, that doesn't work in a highly dynamic, innovation-driven type of model. And later on, we can, if there is a later on, we can talk about the types of evidence that we would want to look to determine whether a potential acquisition is harmful or not. So I think we're looking at, at some revisions. HSR thresholds, for example, reporting thresholds, different, stronger standards for acquisitions of potential competition. For example, maybe the standard should be more like a Section 2 standard, which is, we should prevent those acquisitions that are reasonably capable of contributing to the maintenance of monopoly power, regardless of whether there's a finding of a monopoly or not. So, there are more. I could go on, but in respecting my time, I will leave it at that. Thank you.
Sorry. Thank you, Diana. Do we have a quick question for Diana? Otherwise, I can supply one.
Ooh. I want to say something real fast, because this responds both to Tad's point, which I didn't take as an attack at all, and also mainly cheers on Diana. As usually happens when Diana speaks, it made my heart sing. I think I agreed with every single word of that. Here's two things. Tad, if I took your point correctly, you thought the history of antitrust working more like sort of a law enforcement tort regime that doesn't try to regulate or oversee indefinitely, and rather lets markets do their thing and polices bad behavior from time to time. You think that works better than the history of sort of government oversight, either by regulators or by court? I couldn't agree more. That's my vision of weirdly, I've grown into kind of like a free market classical liberal. I just think that markets don't protect themselves very well, and you actually need that tort system. Sometimes we've killed it for not very good reasons. Okay, but that said, I loved everything Diana said, and I think that I'm usually very skeptical of people saying, well, there's something special economically about this market that requires us to establish a new regulator or have new rules or whatever. But I think that digital markets pose some serious problems. The network externality problem is really serious. It's like Facebook isn't worried about there being another Facebook. Once you get 100 million users or so, you're not worried about somebody building a product that directly competes with yours. So we could use competition to try to protect against monopoly, but what if we break up Facebook into 5 Facebooks? It's not like we're going to have 5 Facebooks that then effectively compete to protect innovation and consumer interest and so on. It's just not going to work. The other thing she pointed out that I have come to think is hugely significant is that there are major positive externality problems when consumers are getting free products, and privacy is a big one. Society would benefit, and probably consumers would. Diana said it's information asymmetry problem, and I don't know how it's best characterized, because that seems like a problem too. Consumers don't properly price their own privacy interest, it seems like, and they definitely don't incorporate societal value that would follow if we had better privacy provided by markets. And my point is simply to ask whether we need some additional law on this. You simply have to ask, would we get better privacy if we had a whole bunch more firms selling consumer products? I think it'd help. It couldn't hurt, but it's not going to do the job.
Interesting. Nicolas, did you want to jump in?
Yeah, so I have a few remarks on what I heard. So let me just try to structure my thoughts. So I heard Facebook is not too worried that there's a next Facebook anytime soon, but is that a relevant question? I mean, most people who observe the working of competition in the tech industry tell you that competition in the tech industry does not take place by competition through direct entry with perfect substitutes. The logic of competition in tech, and this is why the US has such a dynamic economy, and trust me, I'm from Europe. Sometimes I look over the US and I'm like, wow, if only we had, that amount of entry, new firm creation, and economic dynamism in our economy. The logic is, you don't build you don't build another Facebook. You build a Clubhouse, or you build a TikTok, or you displace the locus of competition through different products, complements, or new combinations, or as Schumpeter explains. And once you operate with this empirical background in mind, I think the descriptive statement changes completely, because I think on average the American economy is more competitive than not. And so that brings me to my second remark. What I heard rang a lot like there's a sort of antitrust apocalypse in digital markets. Trust me, if there's an apocalypse, it's an apocalypse of entry and innovation. I mean, that's what I hear all the time when I read the news and listen to podcasts recorded on the West Coast in your country. And we're not in apocalypse in Europe. We're in glaciation. It's very sad. I mean, the last large firms created in the digital sector, none of them is European. The large unicorns that everyone talks about are not European. The engine of firm creation in the digital sector in Europe might be broken, but certainly this is not a fact in your economy. So I think if you change your understanding of rivalry, which is not actually the dominant concept in digital in terms of entrepreneurship, you have a very different picture. And then the question becomes, for policymakers, is it worth investing so much energy in a flurry of antitrust cases / regulation in a sector of the economy where signs of competition by indirect entry are on average much more intense than any other sector in the economy? And this is the only question that matters in my mind. And unless we've solved that question, we can't just take for granted that you need to sue someone, right? This is, I mean, I understand that you like to place the discussion on ideological footing. I hate that. I'm very European in that sense. I believe in a sort of rational exercise of policy making and judicial adjudication. And as a rationalist, this is the only question that is in my mind. And it's a preliminary question.
Listen, that's all fine. It's a good point to say, this issue that, as I said, because network effects seem to be very significant in some of these products, competition isn't by horizontal entry. I mean, I said that. It's interesting to say you don't have to worry, you don't have a competition problem because you in fact have disruption in various ways. But, it's you rationalists, you people who have really fantastic economic arguments who've convinced the American courts that non-horizontal acquisitions are irrelevant. They can't possibly hurt competition. So we don't just file a lawsuit. We never do. We didn't stop Facebook from acquiring WhatsApp because Facebook understood Mark Zuckerberg understood before anybody in the United States did that the threat to Facebook wasn't horizontal entry. It was technological innovation that could create the product that would kill Facebook. So he bought it. And the Federal Trade Commission, because government action is so very uncertain and so potentially deadly, that we don't do things until we're certain that we know what's going to happen. The Federal Trade Commission did nothing. So Facebook bought a couple of firms that were the only threats to its long-term dominance. And we didn't do anything.
Well, this is a terrific discussion. We're unfortunately, we are starting to press our available time, and I wanted to make sure that Jeff Manne got in his licks. So Jeff, why don't you take the microphone for a few minutes?
Thanks, Ted, and thanks to the George Mason Law Review and all of my fellow panelists. I always enjoy sparring with you guys and agreeing with Nicolas, of course. One quick thing I don't think I got a chance to say earlier in response to something you said, Chris. I think we've had this part of the discussion before as well. I'm not a conservative, and I'm insulted that you say such things. But given my relative preference for the status quo here, I will assume that you meant Burkean conservative, and I will accept that moniker in this context. But just for the moment, right? I want to respond quickly to something that Diana said as well. I have a bunch of prepared remarks, but I'll probably end up using all of my time just responding to things that have come before, but that's the whole point, right? I don't think it's quite fair to characterize the Klobuchar bill as just a sort of tweak to the consumer welfare standard. I think it's writing the consumer welfare standard out of the law. I think that because as a practical matter, I think if that bill were passed, all cases would be decided on the basis of alleged harm to competitors. I don't think there is any room in, certainly in the exclusionary conduct portion of her bill, for an effects-based analysis. I mean, I'm sorry, there is nominally room there, but given the way the presumption, she sets the presumptions, you'll never get there. All you will have is a debate over harm to competitors, if you even get there. And I don't think we'll ever be talking about harm to consumer welfare, unless you assume that harm to competitors is in fact a proxy for harm to consumers. And I think that's an extraordinarily tenuous assumption. I also think it's important in this debate about potential competition and acquisition of nascent competitors. I think that's a really important aspect of all of this because of the mode of competition that Nicolas described. I mean, I think that we can all agree that we should be concerned with the potential for large companies to anticipate and destroy the potential competition that may arise from some, oblique perspective. But I think we dramatically overstate both their ability to do so and the consequences of their doing so. So in the terms of ability, really important to note that buying one potential competitor does not kill potential competition. The fact that maybe Instagram was indeed Facebook's biggest potential competitor at the time means they spent a lot of money to take out one potential competitor and done nothing to prevent the rise of a virtually limitless stream of other ones to come along. And Facebook acts exactly that way. They act like you would expect a company to act that was facing a constant threat of potential competition from unanticipated sources. It's constantly changing its product. By the way, in terms of privacy in particular, something I'll try to come back to. It is copying, right? Potential, when a new entrant has some desirable feature, it implements it in Facebook. It doesn't do that because it does that because it's potentially worried that this mode of interaction with your social network will become the dominant one, and it wants to make sure that it can try to stave that off. The consequence of that, of course, is this great new ideas are incorporated into Facebook, which means they are given to 3 billion users rather than the, say, 100 million users that may be using the small new entrant product to begin with. Now, I'm not saying that's dispositive, because there's the potential for the dynamic competition effects to outweigh the relatively short-term benefits of Facebook co-opting ideas from new entrants and making them less viable as competitors. But you can't deny that it's a massive consumer benefit, and it is the process of competition. It's what we're supposed to be encouraging. We want this to happen. And if at the end of the day, we had a Facebook that was constantly incorporating the best ideas of its new potential competitors, never displaced by any of them, but operating as though all of them could be potential threats, and therefore taking their best ideas and incorporating them and giving them to people, that would be a win. That would be a great world from a competition perspective. Totally agree that there may be other social and other issues that are not in the province of antitrust, and we can, well, I don't think we should talk about them, but we as a polity should certainly be talking about those. The other thing about potential competition is, far from the purchase of a potential competitor, as I described it, may actually not do much to alleviate the stream of potential competition. But also importantly, it may actually incentivize the stream of potential competition, right? We all know that a lot of these companies rely on the prospect of an exit through purchase by a larger company to justify the investment in them. And the fact that Facebook and other big tech companies are out there constantly purchasing these potential competitors actually incentivizes the creation of more of them, and or arguably does. I don't think it's been disproven. I know that there are people out there who think this is unlikely because of enormously constrained theoretical papers that might suggest that, but I think the empirical evidence is very different, especially along the lines that Nicolas suggested about the difference in venture capital and startups in Europe and the US, of course, due to a vast number of factors, not just antitrust. So I'm going to turn to a couple of my sort of more prepared remarks that actually touch on some of these same issues. I wanted to start by
we are getting pretty close to our stopping time. So
all right, well then I'll pick one.
Broad strokes or whatever.
I want to suggest, I think we've been sort of dancing around this the whole time, and I wish we had more time to discuss this once I say it. I think I think this relates to Diana's data point, by the way. I think there is this sense that these platforms are essential facilities, essentially, right? I think, Chris, you might have mentioned this as well. There is this, there's a general sense out there that the kind of response we need to these companies is some sort of mandatory access, common carrier-like treatment. We're seeing that with the DMA. We're seeing that with the House Judiciary Committee report. We're seeing that in some of the antitrust actions that are being taken. And I want to, and we hear a lot, probably not in the cases themselves, but certainly in the politics around the legislative reforms, this notion of gatekeepers, right, being tossed about. But I think it's a really odd sort of essentiality. And I think our understanding of what it means and what it implies in terms of remedies in this context is really stilted. In particular, I think of the analogy with mandatory open access to the only harbor in a city that's accessed only by the sea. Think of that as a true essential facility. Is a sort of mandatory access on open terms to Amazon for merchants, or Android for other search engines, or Google search for vertical providers. Is it really analogous to that? And I think the better analogy is opening a platform like those, or preventing conduct that might impede the entry of these sort of complementers using the platform, isn't analogous to mandating that any and all ships be allowed to use the harbor. It's akin to mandating that any and all tugboat operators be allowed to operate in the harbor. we're actually talking about sort of, for the most part, companies that build their business models to be dependent on another company, and then having made themselves dependent on the platform, declare that the platform is essential to their business and we have to have open access and we can't compete on equal terms and the like. I think there's a massive difference between those two sort of situations. It might be different if we were talking about access by users to platforms, right? And we're having that debate in a sense in the Section 230 platform liability sort of debate. But that's not where the antitrust debate is. We're really talking about access by companies that have built a particular business model with taken on a particular level of risk, essentially asking for a subsidy for them to take even more risk. And I don't think we have any basis for believing that that's what we should be subsidizing instead of nothing, or even the platforms themselves, which are actually providing this massive value. So in the interest of time, I'll stop there. And
yes, I'm sure that I see that probably all of the other panelists would like to respond to that last point in particular, but I have to reserve your right to respond to the next occasion that we come together. Unfortunately, there are just so many massive, wonderful issues that arise out of this discussion. We can't fit in everything. So I'm going to bring us to a close here by expressing my very, very sincere thanks to all of the panelists who agreed to contribute and who have obviously devoted enormous and very, you've put a lot of mental electricity on this problem. And it really shows. You're so well prepared and articulate on so many of these facets of this vast issue or set of issues. But thank you very much. This concludes the session. I would ask the attendees, please return at 4 p.m. Eastern today for our next session, Antitrust Litigation 2021 Outlook, which is sure to be interesting as it is moderated by Judge Ginsburg. And tomorrow we will have 2 more panels. The first one is the future of FTC remedies, and the second is antitrust and collegiate athletics. In the meantime, we look forward to seeing you at our panel at 4 o'clock Eastern time today. Thank you again all very much.
Thank you, everyone.
thank you, Ted.
Thank you.
Thanks, everyone.
Thanks a lot.